recording and then admit everyone. Everyone's in, Teresa.
All right. Hello, everybody. Thank you for being here on this wonderful Monday. And sorry about starting a few minutes late. So we're here with the Ballot Question Advisory Committee, and we're here to get input from the public about what our hold on, sorry, 1 second. Technical difficulties. All right. So the Ballot Question Advisory Committee, we meet to basically give the we try to inform the process for the Democratic Party to we present, there's ballot questions that come to voters in the election in November. And these ballot questions are not, they're worded very specifically. And what the Ballot Question Advisory Committee does is we make sure that the Democratic Party is able to have a position on the different questions. So we have been meeting virtually for about a month now. And we've been going over the pros and cons on each different question that we have. And I believe you guys all know what the questions are. We put together a list of pros and cons, and we give a report that you guys are here to be a part of the public hearing part of it. And we give a report to the precinct organization, which is in about a month. And the precinct organization meets and they make the decision whether they will approve or they will be for or against the ballot question or take a no position. We don't have any input over the text of the questions. We just kind of we put together the pros and cons for the precinct organization to first vote on it. After the precinct organization votes on it, it goes to the Montgomery County Democratic Central Committee, and then they vote whether to reject or approve the work that the precinct organizations had already voted on. And then what ends up happening is we make a recommendation that the Central Committee makes the recommendation so that the voters, so that Democratic voters have an idea of where the party stands on stuff. My name is Teresa Warman. I probably should have started with that. I'm the chair of the Ballot Question Advisory Committee. I have two co-chairs. One of them is Jen Michaels, who's on the call, and Elliot Greenwald. And I'll turn it over to them for a quick few words of wisdom. They've done this process before, so they're very familiar with the process. All right, go ahead, Elliot. I think you're unmuted.
Yeah, okay, go ahead. Yeah, I'm Elliot Greenwald. I'm one of the vice chairs of the committee, and glad to be here. And I think Teresa went over everything very well. Just to clarify one point is if the MCDCC agrees with the vote of the precinct officials, that's the party position. If MCDCC disagrees, then the party takes no position, and so then the sample ballot doesn't have a position on that particular question.
All right, thank you, Elliot. All right, go ahead, Jim. Oh, you're muted.
I'm muted. Okay.
There you go.
Hi, I'm Jim Michaels. This is my second time participating on the Ballot Questions Committee. I'm a precinct official in District 16, soon to become a member of the Central Committee. This is one of the more interesting things we do, and one of the more challenging things we do. I should note that the ballot questions this year are fairly legalistic. And as a lawyer, I appreciate that one of the hardest part about this is doing the voter education piece of it. So that the folks who are voting on these questions understand what it is they're being asked to vote on and decide. I hope that the Ballot Questions Committee's written report will contribute to the public education part. It will be, that report goes to the precinct officials on the central committee probably around the last of April, 1st of September, so that they have it in time to read before the precinct organization actually votes on September 14th. But after the party takes its positions, it has been historically true that at least part or all of that report will get posted online so that the public has the benefit of understanding what the organization saw in terms of the written background and summaries of the history of the questions. The other thing is I don't know how many people had a chance to actually register to speak this evening. It was relatively short notice, and folks may have attended tonight with the intention of speaking who didn't actually register to speak. So it is our intent at some point to open it up to people who raise their hands and have statements they want to make or questions. It is to allow a more open process than we might otherwise have with the pre-registration part of it. So keep that in mind as you're listening and going along. If it's something you do think you want to say or you want to ask a question, you'll have that opportunity to do so, even though you didn't pre-register to do it.
Right. This is Elliot. I was just going to add one thing based on what Jim said. The way to use the hand raising tool for those who are not familiar with it is at the bottom of your screen is a little icon that says reactions on it. And if you open that icon then one of the choices, which is on the bottom part of that, of what opens up, is a little picture of a hand raised, and you just click on that and your hand will go up, and that will actually put your screen in a place where Teresa can see it, because it will be on the first of the 3 pages of screens.
Great, thank you, Elliot. Thanks, Jim. I think we'll go ahead and get started. We also wanted to recognize Michael Tardif is here from the Democratic Central Committee. You guys all know him as a comms dude and wonderful member. And he'll be running our tech. So thank you guys. All right, so I don't think anybody signed up to speak on behalf of this, or against this question, but we're going to start with question A. So this is one of the county charter questions, and this is a charter amendment by the active county council. And what the question, oh, there you go. Awesome. Thank you, Michael. The question is in front of you guys, and I'll open up to see if anybody wants to raise their hand to see if they want to give any comment for or against this question, or just an informational testimony. Let's see. And Jim or Elliot, I don't know if you guys wanted to go over this question a little bit while we wait to see if anybody's brave enough to raise their hand, or if we want to go on to the next question.
Well, I could start by
Yeah, go ahead.
I can start by describing, we did have one written comment submitted late this afternoon by somebody who just wanted to know where this question was coming from. And I can tell you, I was attending the council session the day they adopted this, so I did hear. I think the easy answer is it's not coming from anywhere in particular. There was no specific concern by the existing county attorney or our recent county attorney who retired after long years of service. I think it was just believed that this was sort of a fundamental flaw that was always in the system, and that they decided this was a good time, since we had an acting county attorney, to install a guardrail as a precaution in case there would ever be a future need. And the idea is that it's intended basically to prevent any situation where, because the county's attorney's opinion favors either a view by the council that the executive disagrees with, or a view by the executive that the council disagrees with, it would prevent either of them from trying to fire or remove the county attorney as a reprisal matter. And so that it would take the consent of both the council and executive to remove the county attorney.
Okay, thank you, Jim. And could you, just because it's a public meeting, could you tell us who asked the question?
Who asked the question?
Yeah.
At the council, it was presented by
No,
Council.
no, no, sorry. Who submitted the question about this?
Oh,
yeah, the comment.
that's a good question.
It was Marcy Greenstein.
Okay, thank you, Michael. Does anybody else in the, oh, there you go, Zach. Go ahead.
Hi, Zach Wida, he, him. My question is just in terms of this amendment, it says the council would request or would consent to the removal of the county attorney. Would that be a simple majority vote of the council, or would there be a requirement that it go beyond the a simple majority vote?
You know, that's a good question. I was there. I don't remember the discussion. It may be a super majority, but I did have to look at the county charter and not the text of the ballot question, but the text of the actual resolution and county charter amendment that they drafted, which is online. I mean, it's a good question. I just can't remember the answer.
We can also look into that and get back to you, Zach,
Thank you.
of course. Anybody else? I see somebody in the chat asked if somebody could explain the current situation. So I'll turn it over to one of our attorneys. Attorneys on the board, not attorney for the committee, but just on the board.
The question is what the current law reads?
What the current situation is. And
So
the question from
current-
Jack and now.
So currently, the county executive names and appoints a county attorney. And there is a requirement for council confirmation. But once confirmation occurs, that person is the county attorney until the county executive decides to remove them, or they resign or retire. And so it's strictly at the pleasure of the county executive. The council has no say. All they can do is confirm whoever gets appointed after the fact. So if somebody resigns and the county attorney resigns or gets fired, then the county executive picks a new one and the council can confirm again. That's how it currently is.
I will also note that there is not like a specific action or instance that's triggering this from what I understand. So I'll note that. And then Jean, oh, I see Michael answered, but yeah. So Jean in the chat asked, asking if the committee was speaking for or against it. And Michael answered that we don't speak for or against anything, but we draft a, like I said earlier, we draft a report. And then based on the pros and cons, the precinct organization considers that, and then it goes to the Democratic Central Committee and then to the voters. Let's see, anybody else for question A? For or against, or just speaking on this question? All right. Oh, there it is. Michael Tardif, the retiring county attorney, recommended this charter amendment. The county attorney, got it. All right, so I think we can, oh, go ahead. Sorry, I didn't see your hand.
Yes, I just wanted to ask, so what is the current, I mean, we're
Oh, I'm sorry, could you state your name?
this, so what is the current procedure? I mean, so, I mean,
Current
this
procedure. I believe-
amendment, what is the amendment actually to, I mean, what does it change?
Could you state your name just because we're in a public hearing?
This is, I'm sorry, this is Roz Mara,
Oh, thank you.
okay, and so,
From what I understand, and then I'll turn it over to Jim and Elliot, who know a little bit more about this, but from what I
Yeah.
understand right now, it's just at the pleasure of the executive. But I'll turn it over, Jim.
Yeah, no, that's right. It's at the, basically the county attorney can be removed by the county executive who appointed them, and the council has no say. What this would do would set up a process where if the county executive wishes to remove the county attorney, then after he gives notice to the council has a certain amount of time to decide whether they agree or disagree, and vice versa. If the county council decides they want to have the county attorney removed, then they just have to give notice to the executive, and then the executive gets a certain amount of time to decide whether they agree or disagree. The county attorney serves both of them. The county attorney provides legal advice to both the council and the executive, and so it's deemed to be appropriate that either one of them could initiate it, but they both have to agree on removal.
So currently, what is the process right now? What are we
The process
changing?
right now is the council decides that person is been removed and that person is removed. There is no
Okay, okay.
of the process.
All right, thank you. Thank you. Thank
Hey,
you.
thanks, thanks, Rosalind. Any other comments? Oh, has the current Zach in the chat asked, has the current county executive and the current county council taken a stance on this? Jim?
Well, the council took a stance on it when it voted. Basically, this ballot question comes from the council who passed a resolution requesting that it be put on the ballot. The council voted unanimously in favor of the members who were attending. I think there was one council member not attending that day, but the members who were there voted unanimously. And the county executive's office did submit a written testimony on the proposal. And basically, the executive, it supported it in general. It had a few comments and suggestions for how it would like to see the language slightly revised and amended. The council did not accept any of those suggestions, but the executive did not oppose it. It just recommended some changes and tweaks that were not made. So that's as much as we know about where the executive stands on it.
Great, thanks, Jim. Thanks, Zach. Anybody else on question A? Okay, we'll move on to question 1, I believe. Yeah, all right, question 1, and this is one of the state constitutional questions, and it is on our screens for everybody to see. This is about renaming the Court of Appeals and Special Appeals. I'm so sorry, I can't remember who was taking the lead on the committee on this. If you wanted to speak, or I'll turn it over to
I can speak, or if Jim wants to speak.
there you go. All right, Frankie, go ahead.
All right, this is the first of 3 questions that deal with reforms to the judiciary that will be before the voters in Maryland. This is simply a renaming ballot question. This is state constitutional question 1 that would rename our appellate court from the Court of Appeals to the Supreme Court of Maryland, and the Court of Special Appeals to the Appellate Court of Maryland. Under the new law, the judges will have their titles changed. The main impetus for this came from the judiciary so that it is in line with peer states. I believe 48 states use 48 states utilize this nomenclature of a Supreme Court of some sort. And that is the main justification to bring us in line with other states. And a large part has to do with prestige, that the rulings of our highest court, the Court of Appeals, should be respected as a Supreme Court when read by scholars, and this clears up confusion. That's the main justification for this ballot measure.
Okay, great. Thanks, Frankie. And thank you, Michael. I should have mentioned it. Frankie Fritz is one of our committee members. Does anybody in the audience have any comments regarding question 1? All right, seeing nothing, we'll move on to the next one. This is question 2, and this is this is a fun one. All right, this is eligibility to serve as senators and delegates, and this is about place of residency. I can't remember, I'm sorry, I don't have my notes in front of me. Who was on the committee that was in charge of this?
Well, I know, and he asked me whether he was going to have to make a presentation. And I swear to God, he was not going to have to. If he's on here, I already apologize. Is Michael here?
I am.
There you are. Thanks, Michael. Go right on
Okay.
ahead.
So now you're never going to believe,
Michael,
you're not
this
going to
is
believe anything I
Michael
ever tell you
Pryor.
again. So
And this is
That's
Michael
okay.
Pryor. He's also a committee member.
Okay, So this is a proposed change to the Maryland Constitution to address an issue that the Maryland Court of Appeals, still called the Maryland Court of Appeals for now, found about 15, 20 years ago. Question becomes, obviously any state legislator has to live in the district in which they run for office, a state delegate or state senator. But the question became one of whether they domicile in that district or whether they have their place of abode in that district. And both those terms have different legal nuances about them. But the central thrust is that you have to live in the district. But what this amendment is proposing to do is to change it from domicile to principal place of abode, which means this is the place where you lay your head down to rest the majority of the time, as opposed to just having a house in the jurisdiction for tax purposes or for that's where you happen to have your driver's license located or related to that location. Here, the proposed constitutional amendment is going to require that you actually have to live and sleep at this location in order for that location to be your primary abode for purposes of being eligible to run for office in a specific district. That's all it is, because there was a case about 20 some odd years ago involving a state senator from the Baltimore City area who claimed to have a domicile in the city of Baltimore, but was effectively living at a condominium in Baltimore County. One of his primary challengers challenged him, saying he didn't actually live in Baltimore City for purposes of being on the ballot. Case went all the way up to the Maryland Court of Appeals. They said, well, it's a close call, but we're going to go with domicile. But the Maryland General Assembly and State Senate unanimously endorsed this constitutional amendment. I believe it's 137-0 and 47-0 endorsed this amendment so that in order to be eligible to run in a district, you actually have to have that as your principal place of abode, meaning that's where you have your stuff, that's where you sleep, that's where you actually live for the requisite period of time. That's it.
Great, thank you, Michael. Does anybody have any comments on this one? And I just want to say for the record, we will also be accepting written testimony for all of these, and I'll give out that information at the end. All right, we'll move on to the next one. All right, and this one is a Frankie question, I believe. This is the civil jury trials, and I'll turn it over to Frankie again.
Yes, so in effect, when a plaintiff files suit in a civil suit in court, there is the defendant has a right to a jury trial in cases where the amount in controversy, so that in general terms means the amount that you're being sued for, with some exceptions of legal fees, the amount in controversy, if it is more than $15,000, the defendant has a right to a jury trial. This is pretty widely supported in the legislature amendment that would raise this threshold. Again, it's been raised many times. I believe most recently in 2010, it would raise the amount to $25,000. So this would in effect reduce the ability of defendants to claim a jury trial in a civil case when the amount in controversy is less than $25,000. It would eliminate that right to a jury trial on the defendant's part. If you're the plaintiff, you can still file in the district court, which is generally you just have a shorter trial before a judge, or you can or you have the ability to file in circuit court, which would require the impaling of a jury. Jury trials tend to take longer. They tend to utilize more expert witnesses and other kinds of factors like that, which tend to prolong the hearing, increase the complexity of the case, while a district court tends to have more judges who tend to be subject matter experts who are equipped to make a decision relatively quickly once the evidence has been presented to them. This very importantly only applies to civil trials. This does not apply to criminal cases, but this is about civil jury trials, and only when the amount in controversy is between this range, 2015 currently, and would go up to 25,000.
Okay, great. Thanks, Frankie. Anybody in the audience have any comments for this one? All right.
What question? I may.
Mark,
Mark Pastor here.
go ahead, Mark. What's your question?
It sounds like the choice for jury trial is already inequitable in terms of the defendant versus the plaintiff. It sounds like this just increases that. Is that a misunderstanding of what this question does? And I guess the question is, how does this impact justice for both sides? That's probably a better way to phrase the question. Thank you.
So it's hard to speak in generalities, and we're not here to take a position on the question itself. So it is a little difficult. Otherwise, I would be giving my opinion on the question when we talk about equity and justice. About that's I don't want to say subjective, but I will say that in many cases, the proponents of this question note that there is almost a 100% in certain industries, such as cases where the plaintiff is someone who's been injured and the defendant is an insurance company like State Farm, for example, or other insurance companies who lobbied for this legislation. It tends to be the case that almost 100% of the time, the insurance company, who, when being a defendant, prefers a jury trial. The defendant does not have to request a jury trial, but in many cases they do. So in a certain sense, the plaintiff doesn't have a right to a district court trial. And this would change this, and this would help plaintiffs get more cases heard. And the idea would be more quickly in front of a district court. So if you if you're someone who, in the cases of the proponents who tended to be trial lawyers, they argue that the people who, if you were in a car accident, if you faced an injury, you want a quick resolution to your case so that you can get a payout. That is a choice. There are economic impacts to this question. I think that's absolutely fair to say. And it's up to the voter to decide how they want to weigh those impacts. And I think Michael, an actual attorney, has some thoughts.
Sure. Well, let me try to weigh in on this a little bit. I don't think this changes the equity of the situation at all in any grand scheme. This dollar threshold has been adjusted many times over the years. I remember when I first started practicing law about 30 years ago, I think this was set at $5,000 for jury trial. And then it was raised as inflation goes up. So this is not a question of shifting equities or shifting balances. I think it's simply a question of readjusting the threshold dollar amount for when one is eligible for a jury trial to reflect current costs in the state. That's pretty much all it does. It just adjusts the amount based on inflation. The same type of thing happens on the federal level all the time. In order to get a civil case into federal court for what's called diversity jurisdiction, that threshold dollar amount has raised several times over the last 30 years as well, again, keeping track with inflation. And this is fairly standard for most other small claims courts across the country, particularly Virginia, where I also practice from time to time. They've raised the threshold for that as well. So, the fact that this is being raised is not out of the ordinary. I think the only real question here is the amount. Otherwise, it's just to keep up with inflation.
Okay, great. Thanks, Michael. Thanks, Frankie. Go ahead, Jim.
So Mark, let me tell you from a perspective as an attorney who practiced law only in the federal sector for most of his life doing regulatory. When I first saw this, I had sort of a similar question. And so let me see if I could, without sort of taking a position or suggesting, where the equities lie, let me suggest that if you look at the legislative history, and it really isn't a lot, there's just, a few letters, written testimony submitted to the legislature. If you see who the parties are and what their positions are, they really fall into three groups, and you can kind of get a sense of the equities from that. And the one major group is obviously the attorneys who defend insurance companies and other business litigants who are being sued for damages, whether it's medical malpractice or car accidents for insurance. That's the one large group. The other group is the plaintiff's trial bar, the Maryland Bar Association attorneys who represent plaintiffs. And then the third group are some consumer advocates, and there were 3 consumer advocacy organizations who filed testimony. And one of the things when you're doing the legislative history, when you're looking at it, there's 2 bills. There's the bill that amends the Constitution, and there's some testimony for that, but it's the implementing part of it. The other bill, the companion bill that actually implements the legislation by changing the statutes, there's legislative history of that. So to get the full history, you kind of have to read both pieces of it. And the consumer advocates say, look, sometimes consumers are plaintiffs suing insurance companies, but sometimes consumers are defendants defending against a debt collection lawsuit or a creditor. And so consumers can fall on either side of that. And frankly, there were some consumer advocates that said, hey, if I'm a consumer and I'm defending a debt collection case, maybe I have some leverage. Maybe I have some leverage by requesting an expensive jury trial because my creditor or debt collector wants a really fast payment and wants a quick case, and they don't want to spend a lot of money on a lot of discovery and jury trials. They just want to get paid fast. So I've had attorneys representing consumers say, sometimes that's good leverage as a defendant to threaten a jury trial, even though consumers don't want to pay for jury trials. Really, they have attorneys who might get paid under statutory attorneys awards. So the equities can depend on what kind of case it is, and there might be consumers on either side. So inflation is part of it. But I think if you read the letters that are submitted as testimony, you can see that it's really about leverage. Who has the most leverage in getting a settlement, and whether that falls in this case for the consumer who's suing an insurance company defendant, or whether it's the defense attorneys who are trying to make these cases more expensive in circuit court with juries in hopes that they'll get a quicker settlement from the plaintiff. So.
Okay, great. Thanks, Jim.
Thank you for all of that, making it even confusing to figure out which side to come down. But thank you.
Thank you, Mark. Are there any other comments from the audience on this question?
Well, I will just say that I hope that when the committee comes out with the recommendations, I hope that you'll appreciate them because this is definitely there's a lot of discernment, and this is why we're going through this process, right? We want folks to have an open forum to be able to discuss this. We definitely thought about it a lot internally as well. And we want to make sure that the central committee has the best information possible to make a decision. But, we definitely something that you do want to look over multiple times. You don't want to make an uninformed decision. And it's good that we're asking questions about it. So thank you for your question.
Thank you, Frankie. All right, any other comments for this one? All right, let's move on to the next one. This is the fun one. Obviously, we all know that there's a constitutional amendment that we're going to be voting on the use and possession of cannabis. So I'll turn it over to Samir. Samir Paul is one of our committee members as well.
That's great. It's been a pleasure to work on this, in particular with Kina, who is my sort of co-head on this question. And I'm actually going to throw it to Kina to lead us through the discussion here.
Hi, everyone. Good evening. Just in short, giving you a quick summary. After the most recent Maryland legislative session tried, but did not successfully pass this more comprehensive cannabis legalization by the end of session.
My name is Jackson. Sorry.
The bill.
Wait,
Dog's running out.
I think we have someone who's off mute.
Yeah, if you're not speaking right now, could you please mute yourself? Thank you.
I've muted that individual.
Oh,
Michael.
we're quick. Okay, so as I mentioned,
okay.
after this Maryland legislative session, this amendment had not passed successfully by the end.
I keep
No.
getting muted. Why is that? What did I do?
Any technical issues?
No, the individual whose name is
Actually.
Jackson, Jaxson.
What?
If
Yeah.
you are unable to remain muted, I'll have to remove you from the meeting. Thank you.
All right. Sounds good. Okay, hold on. Let me mute myself.
Thank you.
Alright.
Michael. Sorry, Kina, go ahead.
No problem. Just want to make sure I'm pausing people some time. All right. So as I mentioned, after the most legislative session that had passed, unfortunately, this amendment was not able to get passed by the end of the session. So the bill has now been kicked back to us, the voters. And this measure would legalize cannabis possession and use for adults over the age of 21. And it also instructs the legislator to pass a regulatory framework for sales, criminalization, and tracking of recreational effects. So in short, a yes vote supports legalization of marijuana for adults 21 years or older beginning July 2024, and redirecting the Maryland state legislature to pass laws for the use, distribution, regulation, and taxation of marijuana.
One interesting feature of the way the legislature set it up is that there is this additional implementation bill that I think Kina referred to, HB 837, that takes effect only if the voters approve the constitutional amendment. That contains a bunch of, like Kina was saying, a bunch of measures about expungement and funding of different commissions. But there is a significant open question as to what the licensing and regulation scheme will look like, and that's going to be taken up by future sessions by the legislature, by the assembly.
Great, thanks, Kina. Thanks, Samir. Does anybody in the audience have any comments about this one?
I have a question.
Go right on ahead. Can I have your name, sir?
My name is Liam Geller. My question is, have there been, I'll start my video, okay? My question is, have there been concerns or studies about how it might increase traffic problems and I mean traffic accidents? That people might start driving on high too much of the time.
Yeah, I haven't seen specific studies produced during the legislative process about impaired marijuana driving, but it's a known concern, the detection of impaired marijuana impairment and cannabis impairment, which is a little bit different from the way you do it with alcohol. So that's the concern that you've raised is one that I think people are sensitized to, but I don't know of any specific literature on it that was produced during this process.
I do know that as part of the legislative process in Annapolis, that issue did come up in the hearings. Yeah. Go ahead, Jean.
I'm Jean Capps. I just find it interesting because this looks more like a survey of opinions as opposed to, I mean, it says, do I favor the legalization of the use of cannabis by an individual? If this passes, what does it actually do? Does it, because you were talking about the amendment, but the constitutional amendment's not presented there. It just says you favor the legalization, but you just presented a lot of things about the the sale and the regulation and the taxation, but that's not in this ballot question. Can you
right.
explain to me, if this passes, does that mean all of those things will happen? Or you're just saying that it's just sort of a opinion survey?
Right.
Yeah,
This is a
so
really
that's
important.
Okay, go ahead, Mr. Mayor. I'll take it over if there's any things that I want to add.
You did the next one after this. So really important question, sort of procedural question for how this was. If you look at the text of HB1 of House Bill 1, it includes this question that you're seeing that's going to appear on the ballot, and then it includes other language that actually amends Article 20, or that adds Article 20 to the state constitution. So this ballot question appears in HB1, but it's not the only thing in HB1. This is what's going to determine whether or not Article 20 is added to the Constitution. So that's HB1. Then there's this second implementation bill, HB 837, that was also passed by the Assembly. And that contains a bunch of stuff, like I was saying before, and like Keena was saying before, about expungement, about these various commissions that are going to be started. About one of them is like a community reinvestment fund with that will sort of aim to address some of the social justice concerns around marijuana legalization, a whole list of other things. And that has already been passed by the Assembly, but its effect is contingent upon the passage of or approval of the ballot question presented to us. So that's the second thing. There's HB1, and which includes the ballot question. Then if the ballot question is approved, then HB 837, the implementation bill, will take shape. And then you mentioned also the licensing and regulation of the legal recreational industry. That's not been created yet. That system doesn't exist yet. That will be taken up by the Assembly in the future. So there will be like a future bill that structures that whole recreational growing industry. Does that help answer your question, Jean? And is there anything you want to add, Keena?
I don't think that will clarify it for the voters. I think the voters will probably think that if they vote for this, that it's going to happen. And so that those other things, if you're saying that the system, so to speak, it's ready to go, all they need is the voters to say that they want it, and that's one thing. But if the voters say that they want it, and there's all these other things that are still up in the air, I think that will make them very cynical. I think they'll be very upset. So I think we will need some significant education for us and for us to explain what will happen as a result of this if it passes, or if there's going to be a whole lot of other things that have to happen before it becomes a reality. So I don't know whether it's this committee that would give us that, or something from the legislature, so that we would be able to discuss this. I live right on the border with DC. They have much more liberal laws than we have. And I've been to Colorado, where I can walk in, and it's not exactly like buying a pack of gum. I mean, it is regulated, but it's fairly easy, and it's been in place for quite a long time. So I think, you have people who are in favor and not in favor of it, but for those who are in favor, I want to be able to let them know how far along on the process this, by voting for this, they'll get it. It's not so much for the election itself, but it's for what they can expect as a result of the election.
Right. And I think if anybody asks you what to expect, the answer should be, this will essentially, it will start the process, and it will trigger the first implementation bill to take effect. And at that point, it'll maybe set the table for the Assembly to take up the further issues around licensing and regulation. But I think for our purposes tonight, if the goal tonight is sort of taking public feedback, then the lesson here, and I think this is something Keena and I have been thinking about, is explaining that clearly in the eventual sort of question guide that we put together.
Right.
Yes, I guess that's pretty much what I'm saying. Either websites or some education that says what happens if they vote for this. If they vote against it, then we know what that will be. But it will be important that we can say, okay, if you want the details on this, I can give you this little bit here, and here's a website or an organization or something, or the legislature itself, to find out really what the legislation would be.
Yeah, that's actually a really fair point. And thank you very much, Jean, for just sharing that. And just to double down on what Samir was just talking about, the way that we're trying to frame this is that it's clear enough to say that this is a beginning step towards something that will hopefully help Maryland legalize cannabis to begin with in a way that's more accessible to the general public and not just to a small entity of people. And as it stands right now, I completely understand what you're talking about regarding the education, so that people really understand how much will happen and when it will happen. In short, the answer is, for right now, we don't have exact answer, but at the same time, what we do know is that this encourages action that wasn't already in place to begin with. And I think that in the spirit of that, that's how we're looking to share information with the public and hopefully encourage them to see the potential of this and also what can be done every year as action towards it.
I mean, I see our area down here is going overwhelmingly in favor of this. Then I think people will come up and say, well, okay, so next July I can buy marijuana. I know that will not be the case. So I want to be able to let them know that this is a multiple step process.
Thank you so much.
Yeah, thank you. Zach, your hand is up.
Thank you. Zach Wida, my question here is, could you give us some insight into how this amendment and the related legislation would impact people who are currently incarcerated for cannabis possession and cannabis related charges, and how it would affect people who have conviction records, and in particular, I have a concern, and others I've spoken to have a concern that the legislature might pass this, legalize this, and then not want to touch the question of how prior convictions affect people for this, and might not want to have any sort of process for expungement. So I wonder if you could give us some insight there.
Kina, would you like to start? Would you like me to start?
Sure, I'll start. So from what I can recall, they're in the amendment, they're looking to work on expungements of some sort for those who have been incarcerated for cannabis up until about 20 years from this year. With that being said, the amount that is paid towards those who were incarcerated isn't the highest, but there is, of course, a budget in place to take care of that. I know Samir had also alluded to kind of like a community initiative to assist those who have been incarcerated for cannabis. And I do think with this legislation, we have an opportunity to take steps towards reconciling that with communities. Now, it's not going to be everyone, and that's really speaking towards the individuals. And this is separate from those who are like maybe businesses who made an attempt towards getting licenses and then were somehow, some way shut down. So we'll start with the official businesses, kind of like a brick and mortar, and then going back towards those who are less brick and mortar, so to speak, and then going back towards individuals. I'll stop with that and then hand it over to Samir. Everyone have any other additional information for that?
Yeah, just to layer onto it, there's the question of expungements for people who have already served their sentences. And I think that my understanding is 837 provides for expungements 3 years after the end of the sentence served. So that's for people who were convicted in the past and served their time in the past. Or serve their sentence or whatever. There's also if people are currently serving sentences related to cannabis distribution and use charges, then this authorizes resentencings. They can petition for a resentencing hearing. It's not obvious to me whether it will be a sort of, de facto 0 months remaining resentencing, but certainly the idea is if you were only there for a cannabis related crime, then you're going to get to you would, I mean, I would hope you would get some time off. But in any case, what the legislation is doing is authorizing the resentencing hearing. That's what we know about this. And then, of course, going forward, it changes one of the things the legislation does is it defines this sort of acceptable civil use amount, which is 1.5 to 2.5 ounces of usable cannabis. So this is like basically leaf, like bud. I'm going to show what an absolute square I am as I talk about this. And with sort of comparable amounts of concentrated cannabis or cannabis products like edibles, things like that, with sort of different amounts there. And so as long as you are using or you're possessing without the intent to distribute within that
Yeah, please.
or sorry, with intent, even with intent to distribute within that amount, it will not be a it'll be a finable civil offense. And if you exceed that amount, that like 2.5 ounces of possession or intent to distribute, at that point, it will still be a criminal offense. So that's my, Zach, to your question was like, what's going to happen with expungement? That's my, like, if you have already served, if you are currently serving, and what do these offenses look like in the future?
Thank you. I have a very quick follow-up, and this question might be outside of the remit of the committee. And if it is, by all means, please just let me know. Is it your sense that if this passes, that the state legislature will want to basically say, all right, we've done this, we don't want to touch this again, and they won't take further action to assist in things like expungements and things like getting people out, doing more restorative justice for people who have been convicted on charges related to cannabis use? Or is it your sense that this opens the door for further potential legislative struggles there?
I think what we're looking at with the legislation is this is opening the door to that kind of thing. There is also this community fund that they're going to be starting. And so presumably that money will go to institutions that are working on these problems. But my sense is this is creating the pathway to those things.
Thank you.
Yeah, and I would go as far as saying also this is speaking more to the implementation of this. There's going to be a directive about the counties being more involved in this process and what that can look like, and that may be a little murky for some. Others might see this as an opportunity to really take advantage of making sure that their community is well taken care of when this legislation goes in place.
Thank you, Keena. Does anybody else have anything to add on this one? And I also saw that in the chat, Michael Tardif said that he's taking notes on the messaging for when the party takes a position on this. So that's very helpful. Thanks, Michael. Doesn't look like I see any more hands up. So then we'll move on to the next question, which is, oh, there it is. It's on the screen now. Circuit Court for Howard County judges renaming the Orphans Court. I believe this is Michael.
This is one of mine.
All right, Frankie.
No, you're good. Yeah, and just to clarify something that I said previously, when we look at this committee, the Ballot Question Advisory Committee, I misspoke. Just to clarify for the record, the Ballot Question Advisory Committee only gives research advisory opinions. What I meant to say was the precinct organization of precinct officials makes the decision based on the explicit, based on their own judgment and we are only providing an advisory committee position. Obviously, comments that are relevant comments here will be passed along. Yeah.
All right, awesome.
Teresa, I need to interrupt for a moment. Brenda Wolf's account has been hacked. She did not post those comments, and
Okay.
I'm removing that person, and I'm removing another person from the meeting. Okay.
Kill yourself! Ah!
There we go.
Thank you, Michael. All right. Does anybody in the audience have any comments on this question?
Oh, and I can also do an interview, just do an overview very quickly. While we wait for folks, if there are any comments that are relevant to this question.
Shut up.
This question is local to Howard County specifically. Currently, an orphans court refers to the probate court, which handles the disposition of wills. So people who, residents of Howard County who have wills, those issues, when necessary, go before a probate judge known as an orphans court judge. They are currently in Howard County elected, but there is this question that would change it so that the circuit court judges would assume those responsibilities. They would sit as the orphans court judges. And that's really the main overview of it. Currently, an interesting quirk of the system that is part of the question, you do not need to be a lawyer to be an orphans court judge. So that would be a change. And the Howard County delegation proposed this legislation to make sure that we have an option, that the voters have the choice whether or not they want to retain the orphans court or merge its responsibilities into the Howard County Circuit Court.
Thank you so much, Frankie. Shut up. Michael, there's more in chat. I'm sure you're already on it, but some more.
I'm working on it.
All right, awesome. Thank you. Does anybody have any questions? I see Rosalind wrote in the chat, would this question be on our ballot? Yes, this question will be on our ballot, even though it is Howard County. It's still a constitutional amendment. So yes, it'll be on our ballot.
And just to clarify for folks, this will need to pass in Howard County and and statewide in Maryland for it to take effect. That's just part of the constitutional process. Article 14, Section 1 of the Constitution requires that all local questions have dual approval from the local voters in Howard County and statewide.
Great, thanks, Frankie. Anybody else have any comments for this question? All righty, moving on, we're on to the last one. And this is a Damascus only question. And Jim?
So this question has actually gotten zero attention and very few people know it exists because it actually affects only liquor licenses in Damascus. And only the voters who reside in Damascus, which is I think the 12th election district, will actually see it on their ballot. But it was enacted by the Maryland General Assembly. And it basically has to do with the fact that in Damascus, they more strictly control their liquor licensing than in other places in Montgomery County. And currently, there is one class of liquor license that can be issued in Damascus, and that is a Class H license, which deals with beer and wine and not actually liquor for retail sale on premises where the alcohol is being consumed. And so some restaurants and hotels have a Class H license, but it's not a full license. And so Class B is the fuller license that allows liquor as well as beer and wine. And that's what they're seeking, is to be able to have the County Liquor Control Board issue the full Class B licenses. And so that will require a change in the law and approval by the Damascus voters only.
Thank you, Jim. And just since we're, experts on legislative districts, Damascus is in District 15, I believe. Does anybody in the audience have any comments for this question? I guess not a big Damascus constituency on the call. All right. That wraps up all of the questions that are going to be on our ballots. Oh, there you go, Marco. It's District 9A, I believe, not 15. Well, thank you. Thank you, Marco, for for correcting the record. And I did want to acknowledge all of the committee members. Thank you so much for all of your work. Frankie Fritz is one of our members, Michael Schreier, Samir Paul, Elio Greenwald is one of the co-chairs, Kina Aniam, Preeti Sridharan, Marco Rivera Oven, Jim Michaels, and Faith Blackburn are all part of this committee. And like I said earlier, we're going to be taking all of your comments into consideration, and we will be finishing up the report this week. Hope, we'll be going on the editing back and forth, and next month, September 14th, I believe, the precinct organizations are getting together to vote on these. So we'll make sure that the report is available for the review by then. I also wanted to let everybody know that if you didn't get to make a comment.
Yeah, this is Elliot. It looks like Teresa has frozen. And so I would just let everybody know that's what's going on. And I see that Roz has her hand raised. But why don't we wait for Teresa to get back? And
that problem usually corrects itself, Elliot.
Right.
If you want to go ahead with taking the question from Roz.
Okay. Actually, before I do that, before people leave, the BQAC committee members should stay on, because we're going to meet after this public hearing is over. So everybody from BQAC, please stay on. But Roz, go ahead and ask your question.
Okay, thank you very much. Thank you very much for this opportunity. I just want to ask a general process question in terms of how will you make a decision on what to recommend? Because obviously, we have less than 40 participants in this meeting, so you haven't heard from the general public, you haven't heard from all Democrats. So how would you make decisions for your recommendations? And then what is your deadline for making these recommendations? Well, that's the next question. And then the third question would be, I'm assuming that there'll be some language on the sample ballot regarding the recommendations. So how will this language be vetted?
Okay, I could answer all of your questions. This committee does not make any decisions or recommendations. What this committee does is it prepares a report, which we have been drafting. We are then going to add the input we received tonight into that draft. And that draft will be sent around to the precinct officials and to the Montgomery County Central Committee, probably be sent out next week, because we'll be finalizing it, by the end of this weekend, or maybe by early next week. Then there's a meeting of the precinct officials on September 14th. The precinct officials meet first. We debate the questions after everybody's seen the report, and then the precinct officials will vote on each of the questions, what position the precinct organization is to take. Then immediately after that vote, the central committee meets, and it reviews what and they actually will be in attendance at the precinct official meeting. And then they will either vote to affirm the vote of the precinct official, or they may disagree. They could do either one. And if they affirm, then that's the position of the party, the county party. And if they disagree and want to take a different position, then the Montgomery County Democratic Party takes no position. And what happens is when we as the party distribute the sample ballots to people, those are distributed. I think they're mailed to some, they're mailed out to some people. They're distributed at the polling places, including the early polling places. That will just repeat the ballot questions as they appear on the ballot, and they will say, give the party recommendation, either affirm or vote against, or will not have a position if that's the party position, to take no position. And then that will be but no additional text is put into the sample ballots beyond a repeat of what the question is as it appears on the ballot.
Thank you for that. Just so, how will the precinct officials obtain feedback from the constituents to find out what their thoughts are on each of these ballot questions?
The precinct officials will have the report of the committee in advance, where they see laid out all the pros and cons, as well as reasons not to take a position. So those are the three, because those are the three options that the county, Democratic Party has. And then it's up, then the precinct officials are at liberty to consult with their neighbors and receive input. There's no formal process, but precinct officials are free to do that. A lot of these are sort of more routine type questions. Obviously, the marijuana question is of significant substance, and the county question is substantive. The county question about removal of the attorney, that's substantive. But a lot of the others are more really in the line of technical amendments to the Constitution.
Right. Thank you, Elliot.
Elliot, if I could have a moment of personal privilege as we wrap up. I just want to apologize to everyone for what happened during this meeting. It appears that we were hacked by a couple of malicious individuals. And while I know how to take care of that, we have been holding Zoom meetings for 2.5 years. We've had tens of thousands of Montgomery County Democrats participating in our meetings, and we've never been hacked. So I was a little slow on the trigger to remove those people, and I apologize for that. Now I will be a lot more careful in the future. And I want to be very clear that the comments that were in the chat that appeared to be coming from Brenda Wolf were not made by Brenda Wolf. I made that statement in the chat, but I also wanted to say it here so that it's on the record on video. Thanks, Elliot.
Yes, thank you, Michael. Is Teresa back on? I know
No,
that people-
Teresa had difficulties of her own and is unable to get back onto the meeting.
Okay.
So
All
she
right,
asked that we continue the meeting in her absence.
yes, so I think that is really concludes the public hearing. And, again, the members of the ballot question advisory committee should stay on for a discussion afterwards so we could debrief on what we heard tonight. We'll have to then fill in Teresa later on. But let's all stay on because we're here anyway. Jim, did you have something to say?
Yeah, let me add one closing comment. So for those of you who want to participate in further dialogue and participate in further voter education, we have a whole bunch of Democratic clubs in our county from all the different legislative districts. And I would expect some of them to be having forums between now and election day. And our precinct officials, a lot of them will participate in those forums as well. So there are other opportunities to both listen and participate in the discussion if you want to hear more about these issues or provide more opinions. And I know that our precinct officials are very active in a lot of these clubs, and you all are welcome to be active in them as well.
And with that, Elliot, if we're finished with the public meeting, I would ask everyone to please leave the meeting and for the Ballot Questions Advisory Committee members to remain. Thank you.
Okay, thank you, Michael. I don't think we have a quorum, but we could still have an informal discussion among those of us who are here. But to debrief, because there are 1, 2, 3, 6. There are 8 of us. Actually, it's probably a majority of the committee.
You're only 7. I'm one of the.
Oh, that's right. So Michael,
I'm going to make you the host, Elliot, and then I'm
Okay.
going to leave the meeting as well. And I think we're clear. I don't think we have any more problems. So
We can also end the recording.
that's true. I should end the recording.
Right.
So,
That's a good idea. Thank you.